In contract disputes, conflict of laws issues can be complicated if the contracting parties are from different states. But these issues can become even more complicated in child support agreements if one parent moves to another state. In Haag versus Barnes, we'll see which state's law governed a child support agreement created in one state but challenged in another state. Dorothy Haag lived in New York. Norman Barnes lived in Illinois. In 1954, Barnes met Haag while Barnes was on a business trip in New York. Eventually, Barnes and Haag began a sexual relationship after Barnes told Haag that he loved her and that he would leave his wife to be with Haag. Haag became pregnant after a sexual encounter with Barnes in New York. In December of 1955, Haag gave birth to her daughter in Illinois. The following month, Haag and Barnes entered into an agreement where Barnes agreed to pay Haag $275 every month to support Haag's daughter. The agreement was drafted in Illinois by Illinois attorneys, and Haag and Barnes signed the agreement in Illinois. Haag and Barnes were identified as Illinois residents in the agreement. Also, a provision stated that the agreement would be governed by Illinois law. Haag later moved to New York with her daughter while Barnes remained in Illinois. Barnes made all his required payments to Haag and even paid in excess of the agreement. In 1959, Haag sued Barnes in New York for child support. Barnes filed a motion to dismiss, arguing that he'd fully performed under the agreement and that the agreement must be governed by Illinois law. The trial court granted Barnes's motion. Haag appealed. The Court of Appeals affirmed the trial court's holding. Haag appealed again to the New York Court of Appeals.